Hi, I'm Karan Thapar. Over the last few years, I hope you've been watching my program, The Interview on the Wire. During that period, I've interviewed doctors, politicians, businessmen, scientists, authors, and even the occasional Nobel laureate. For me, it's been exciting. I hope it's been enjoyable for you. But these, as you know, are tough times, and if this program is going to remain bold, independent, and sometimes even defiant, then I think we need your support. At the end of the day, it's a truism, but editorial independence is best defended by the viewers. So if you would like this program to remain the way it is, forthright, outspoken, and interesting, then would you consider supporting us? All you have to do is to click on the description at the bottom. But more than anything else, I hope you will continue to watch the interview. Your viewership means an awful lot to me. Hello and welcome to a special interview for The Wire, with Justice Chandrachud poised to take over as the new Chief Justice of India on the 9th of November. A recent essay in The Hindu analyzes the performance of Chief Justices and judges of the Supreme Court since 2014. In other words, right through the 8 years that Narendra Modi has been Prime Minister of India. And I have to tell you that the conclusion the essay comes to is not complimentary. Joining me now to discuss the essay is its author, the former Chief Justice of the Madras and Delhi High Courts and the former Chairman of the Law Commission, Justice Ajit Prakash Shah. Justice Shah, in a recent essay for The Hindu, you analyze the performances of the Chief Justices and judges of the Supreme Court since 2014, when Mr. Modi first came to power. And you began with a very important general point. You said, when the executive is weak, the Supreme Court tends to be stronger. Conversely, when the executive is strong, the Supreme Court tends to be weak. And then you pointedly wrote, and I'm quoting, since 2014, the executive is once again a single-party majority under the Narendra Modi-led BJP government. Consequently, the judiciary's powers are weaker than before, and the executive is back in control. So you believe that for the last 8 years, the Supreme Court has been weak, and as you put it, the judiciary practically succumbed to the executive's control. That is a pretty disturbing conclusion.
Let me explain, Karan. Theoretically. See, there was a thesis published in 1994 by Mark J. Ramsayr. It was titled as a puzzling independence of the courts. Now, what he says is that when there are coalition governments, repeated elections, no one is sure about his position or his office, and is under apprehension that if one loses power, they will be persecuted. So therefore, all of them want strong courts. So all political parties want strong court in coalition government or repeated elections. On the other hand, when there is a strong executive, then there is a tendency to undermine the judicial powers. And particularly, some governments the executives are vengeful, some strong governments like Indira Gandhi's government. Now, if you recall our history, in 1950, Nehru had majority in first 3 parliamentary elections, but he was true Democrat. During Nehru's time, it was well recognized that the CJI had the final say in the appointment of judges. He had virtually veto. So then it all changed with Indira Gandhi gaining absolute power, then followed by Rajiv Gandhi government. And this powerful executive used every weapon to weaken the judiciary, like transfers or the supersessions, etc. From 1993 to 2013 is the period of coalitions. And during this period, the Supreme Court seized the power of appointment through the judges' case. I would say that this is a glorious period of the Supreme Court, where the Supreme Court was fully active in all the important problems facing the country. After 2014, particularly Modi's re-election, the situation is completely changed. There was some kind of a resistance up to CJI Thakur. After his retirement, all floodgates open. So under Deepak Mishra, Ranjan Gogoi, Bobde, throughout, the judiciary is weakened. There was some signs of revival in Ramanna's time. And I would also say that I acknowledge this as far as the short tenure of Justice U.E. Lalit is concerned.
But there's a sentence in your essay that I want to quote, and it refers to the 8 years of the Modi government. You say of the Supreme Court, and I'm quoting, the judiciary practically succumbed to the executive's control. That is a disturbing conclusion, isn't it? This succumbing to the executive's control is not what one expects, not what one wants.
No, not at all. The role of the Supreme Court under the Constitution is that of a custodian of the Constitution and the protector of the rule of law, protector of the fundamental rights. And there are several telltale signs of this. Look at the cases which are not convenient to the executive, like the Citizenship Amendments Act, abrogation of Article 370, electoral bond particularly, then habeas corpus petition. This is endless. Now, these matters are not taken at all. It's blatant because 4 successive chief justices avoided to take up these issues. These are very important issues, and it is so blatant that you can see the benefits derived by the ruling party from this, what is called a judicial evasion. One legal scholar called it judicial trolling. You are not taking up the cases. Electoral bonds, for example. If you see the ADR reports, thousands of crores had gone to only one party under the electoral bonds. So this is the first sign that you don't take up the cases. Second is, the government's word is almost final. The law officer has a complete sway in the court. For example, after the lockdown, the treatment of the Supreme Court of migrant workers cases. You'll recall what happened during that time. Millions of migrant workers, virtually they were displaced, and their plight can be compared only with what happened during the partition. Now the Chief Justice responded that the workers are getting 2 square meals a day and they have a place to stay. So that's how they would not interfere. When it was pointed out that the workers who during going back to their place, they slept. It seemed that they slept on the railway track and they were all crushed to death. So when this was pointed out, the court said, "What can we do about it?" So that is a government's word becoming final. And the last is the freedom of speech. There is a very interesting write-up by the Indian Express where they considered 10 cases about free speech decided by the Supreme Court. The relief is granted only in 3 out of 10 cases. And all 3 cases are either supported by the government or by the government itself. So in almost all cases where the government is opposing the petitioner, no relief was granted. Now, just see, this played out in Arnav Goswami's case. Arnav Goswami had a petition in the trial court, in the High Court, and the Supreme Court under Article 32. Justice Chandrachud wrote a brilliant judgment in this, and I think he was rightly granted relief. I have no quarrel with that. But look at the treatment to the part where Arnav Goswami's petition comes on the next day. As against this Siddiq Kampan, his case remained pending till very recent time. So there, Chief Justice Bobde said that Article 30, he would discourage parties from resorting to Article 32. Dr. Ambedkar said Article 32 is the soul of the Constitution. And so these are the troubling events which which led me to make this comment.
Absolutely. And for the sake of the audience, I'll quickly sum up the important point you've made, because I think the point you just made is fundamental. There are 4 instances where the Supreme Court, as you say, has succumbed to the executive's control. First, 4 successive Chief Justices avoided hearing critical issues and cases kept getting postponed or not heard. Then, in several instances of matters to do with migrant workers, the government's word was the final word, not what was happening to the poor migrant workers. In freedom of speech cases, only 3 out of 10 cases actually were heard and given justice by the Supreme Court. And then there was Justice Bobde's attitude to Article 332, which Ambedkar had called the soul of the Constitution, but Chief Justice Bobde actually wanted to discourage people using it. And these are 4 examples that lead you to the conclusion, and I'm quoting your conclusion, the judiciary practically succumbed to the executive's control. Against that background, Justice Shah, let's come to what I believe is the heart of your essay for the Hindu. The analysis you do of the performance of all the Chief Justices from 2014 till 2022. These are the Chief Justices who were there when Mr. Modi was Prime Minister. I'm going to focus primarily on Justice Ranjan Gogoi because I think you've had the most to say about him. First, you write, and I'm quoting, the absolute disregard of conflict of interest took its most prominent turn in his tenure when Justice Gogoi sat in the hearing of a sexual harassment complaint made by an employee of the Supreme Court against himself. All principles of natural justice were broken in handling this complaint. Would you explain to the audience, who are lay people, why this was so terribly wrong?
Let me give the background of the case. The Supreme Court employee, a staffer, a female employee, filed a complaint of sexual harassment against the Chief Justice. She also complained about victimization. She said that she was unfairly dismissed, and she was dismissed on the ground of taking unauthorized leave for half a day and protesting against her sitting position. Then then she said her brother-in-law was in service of the Supreme Court as an ad hoc employee. He was dismissed. Her other brother-in-law was in police. He was suspended. So she complained of both sexual harassment and victimization. Now, I am not for a moment suggesting that her charge of sexual harassment was right, wrong. I'm not going into that. Surely, but the charge of victimization seems to be with some substance, because later, in Bobde's time, she was reinstated in service. Now, what happened thereafter is really very disturbing. Chief Justice Gogoi held a sitting on a Saturday, and the board said a caption, something, I don't remember the exact caption, but it was like regarding threat to the independence, judicial independence, etc. Now he sat in his own case. He sat with 2 judges. There was a literally character assassination of this particular complainant. And again, he did not sign the order. He sat, he heard the matter, but the order was signed only by his colleagues, 2 colleagues, not by him. Then he himself constituted a committee to inquire these allegations against him. He appointed 4 judges. Now, Attorney General Venugopal at that time recommended that you better leave it to some former CJIs, etc. Let there be an outsider. Justice Chandrachud had also made similar suggestion. But he himself appointed a committee, and I all respect for the members of the committee. There were 2 women judges in that committee, but how the committee conducted its proceeding. The complaint said that allow me to be represented by an ex-friend, which is a right under the service rules, denied. She said, give me a copy of the material against me or against whatever material is there. So it was not given to her. Her statement was recorded, but her statement copy was not given to her. The order is not published till today. The order is, nobody knows what the order was, and she could not get the order. So this is all terribly wrong. I mean, a judge sitting in his own case, judge who is heading the apex court, doesn't augur well for the institution.
So in a nutshell, this was a very low and depressing time for the Supreme Court. The Supreme Court really let itself down.
Yes, of course. It was now, really yes, sorry, please go ahead.
So you agree, this was a very low point for the Supreme Court?
Yes.
Now, second, you say, and I'm quoting, Justice Gogoi was also obsessed with secrecy and routinely asked for information to be submitted to the court in sealed covers. You point out this happened in the case of the National Register of Citizens, in the Rafale case, as well as the electoral bonds case. Could you explain to the audience why are sealed covers problematic and do they affect the quality of justice?
Let me start with the fundamentals. Fundamental principle is you must know what the other side knows. So the both parties, and then the court decides the matter. The evidence or the information is not taken in sealed covers, excepting the cases like some matrimonial cases, etc. It's not done, or something pertaining to the interest of the minor. Now look at the cases in which this was used. And first I would like to quote the NRC case in Assam. This was a case of National Register of the Citizens. Now, as you know, millions of people lost their right of citizenship. Citizenship is mother of all rights. If you are citizen, you are entitled to various rights under the Constitution. If you are not citizen, you are deprived of all your rights. Now, just imagine in this particular hearing, which actually virtually this executive function of this particular the process was taken over by the Chief Justice, and all the information based on which the final orders were passed, the principles were laid down, was taken in sealed cover. Same happened in the Rafale case. Same also happened in the electoral bonds case. Election Commission was asked to give the report in sealed cover. The obsession was so much. You remember that in the 2019 election, a biopic of Prime Minister Modi came. The question was whether it should be allowed to be shown during the election time. So even that report was called in sealed cover. I believe that this obsession with the secrecy is a trait of the executive, not of the judiciary. Judiciary is about open justice and a fair justice in presence of completely transparent way. So this is something, and then Justice Chandrachud dealt with this issue. A telecommunication license was cancelled. So the government said, yes, we have adverse material against this particular party. And they gave it only to the bench, the Kerala division bench. They said, we will not disclose it, just in sealed cover. Petition was dismissed. The case came to the High Court. Justice Chandrachud said, no, we will not follow this practice. And I'm so glad that this is done away with. In one of his speeches also, but Justice Ramana said it should not be permitted.
Tell me this, Justice Shah. When details are given in sealed covers and denied to one party, that is the litigant in the court, and only made available to the other, does it affect the quality of justice? Did Justice Ranjan Gogoi's obsession with secrecy end up affecting the quality of justice?
Where is the justice when one party doesn't know the basis of the decision which is provided by the other party without even any notice or without any information to the other side, to the other party, which is affected by the judgment?
That's a very important point you're making. Justice Gogoi's obsession with secrecy means that justice wasn't done. In other words, he was a Chief Justice who followed a path that actually didn't do justice to the litigants in his court. Let's come to the third case you make against him. You say, and you make this very seriously, that Justice Gogoi handled habeas corpus petitions very poorly. In fact, you agree with the view that he drove a coach and four through the centuries-old established law on habeas corpus. Now, habeas corpus are petitions that deal with the right to life. So you're saying, in effect, that Justice Gogoi's cavalier handling of habeas corpus was particularly disturbing because it affects the right to life.
Now, let me give the literal meaning of habeas corpus. Habeas corpus means produce the body, produce the person under detention, and justify the detention under law. That's a simple way you can describe a habeas corpus petition. So initially, when the Supreme Court started with A.K. Gopalan, its reading of Article 19, 21 and 22 was very narrow. And then subsequently, the Supreme Court established a glorious jurisprudence on the fairness in procedure. Several principles were evolved. So we have a glorious history about the habeas corpus petition, and these petitions are to be taken with utmost priority. And wherever it is found that there is no justification, there is no legal support for the arrest or the detention, then the detainee has to be released. Now, what was done, not only not taking the case, I will just give one example to make my point. Mr. Tarigami is a member of the Communist Party. He is a Kashmiri. In the wake of abrogation of Article 370, amongst thousands of people, he was also arrested and detained. Then Mr. Sitaram Yechuri, the president of secretary of the Communist Party, he filed a habeas corpus petition before the Supreme Court, which came before Chief Justice Ranjan Gogoi. Now, in that petition, I will just quote the order. The order says that the court is allowing Mr. Yechuri to travel to Jammu and Kashmir and to meet Mr. Tarigami, subject to his filing an affidavit that he will meet only Mr. Tarigami and will not conduct any political activity in the state, in Jammu and Kashmir, and report to the court, something of that sort. Now, just imagine, there was no prohibition in law against going to J&K. So this is where from this order come, that you are putting conditions instead of taking up the matter and to decide the constitutionality of the detention of Mr. Tarigami. This is how the petition was handled.
In addition to the Tarigami case, where the petition was handled, as you point out, wrongly, and conditions were attached which have no basis in law whatsoever, there are many other instances of habeas corpus petitions that were presented to the Supreme Court when Justice Gogoi was Chief Justice, and they simply weren't taken up at all. These were petitions on the right to life, and they were simply ignored.
This is the most troubling part. These petitions have to be dealt with in utmost urgency, and for months together. I mean, now recently Justice Chief Justice Lalit has introduced some reforms, but you ask in the corridors of the bar. I mean, but the people are in prison for months, for years. They are awaiting their day in the court, in the Supreme Court. I mean, this is very, very disturbing part of the way the Supreme Court registry is functioning.
Now you have a fourth case against Justice Gogoi. You say that under Justice Gogoi, judicial evasion grew because he avoided cases of critical importance. Now, you mentioned some of them in earlier answers, cases like the Citizenship Amendment Act, electoral bonds, Article 370. The question I want to ask now is this. Do you suspect that these cases were deliberately not taken up because Justice Gogoi, who was Chief Justice, thought that they would embarrass the government, and to save the government embarrassment, he deliberately sidestepped and didn't take up these cases? Is that your concern?
I cannot probe into the minds of the Chief Justice, but I feel that the not taking up these cases, this is really amount to judicial evasion. And this is starting from 2018 or 19, and it's only after Justice Lalit became the Chief Justice, these cases are being now placed before the courts. It's a sorry state of affairs, and this is a subject matter in media for almost 4 years, and it has not affected any Chief Justice. Nobody, even Ramanna, in spite of all his giving his public speeches everywhere, he didn't think it fit to take up these cases. I mean, this cannot be they take all sorts of cases, and why these petitions concerning which are of national importance are not being taken.
Now, finally, after retirement, Justice Gogoi accepted an appointment from the government as a Rajya Sabha MP. Earlier, Justice Satasivam had accepted appointment as Governor of Kerala. Who do you blame more? The government for offering jobs in specific and blatant contradiction of Arun Jaitley's well-known position on the matter, or do you blame Chief Justices more for actually accepting these jobs?
Let me begin by quoting the 14th Law Commission's report. I think it was headed by Mr. M.C. Setalvad, the then Attorney General. He said that these post-retire appointments are inimical to the judicial independence. He said that this is a very unhealthy practice. The BJP confirmed this position also in their manifesto. Mr. Arun Jaitley repeatedly said that this leads to influencing the judges. In spite of that, Mr. Justice Sadashivam, who retired just few days before or few months before the new government came, he was offered governorship of Kerala. Now it's a purely political position. It's a more ceremonial and political position. Same with Justice Ranjan Gogoi. He was given this Rajya Sabha membership just maybe 2 or 3 months after his debuting the office. So this is not a good trend. At that time, also even thereafter.
Can I ask you this, sir? Who do you blame more? The government for offering jobs or the Chief Justices for accepting them? The Chief Justices know that it is wrong to accept.
I would blame the Chief Justices. I would say that the Chief Justices should not have. I'll just give one example of what one Chief Justice told me. I said, "What's your future plan?" I mean, because of this whole controversy I just asked him, "Are you?" So he said, "What else is to be achieved?" He has occupied the highest position in the judiciary. He said, he doesn't want anything. Kind of. So the judges, and the other disturbing aspect is this: even today, the appointments, post-retirement appointments of the sitting judges are being finalized by the government when they are actually deciding the cases of the government, even before their retirement. Actually, there has to be a cooling period, say 1 year, 2 years, whatever cooling period you want. This has been, suggested by the law commissions, by several jurists, but it's not done. So I believe that the judges should be blamed for this.
Let me sum up everything we've discussed about Justice Ranjan Gogoi before I go on to other points that you make in that Hindu article. I'm going to ask you for your honest opinion of Justice Gogoi. What is your opinion of a man of whom you have had 5 or 6 very critical adverse points to make? What is your opinion of him as Chief Justice?
I can't. I gave the facts to you. He was considered to be a very brilliant judge with great grasp, but these things happen, unfortunately. He was one of the judges who was part of he was part of the press conference. And in fact, he indicated that it was a Loya's case which was a trigger point for the press conference. And thereafter, he said that you need noisy judges. You remember that is.
But then why won't you give me your opinion of him? You've written very critically of him. We've discussed 5 or 6 because what is your opinion of him?
I just don't want to use words for that. I've given my comments on this.
Let's then move on to another very important point made in your Hindu essay. You write about the sycophantic showering of praise on the Prime Minister by sitting judges of the Supreme Court. For instance, in 2020, Justice Arun Mishra called Mr. Modi a versatile genius and an internationally acclaimed visionary. A year later, Justice M.R. Shah said he was our most popular, loved, vibrant, and visionary leader. Now, judges know only too well that this is wrong. It's unacceptable for them to speak of the executive in this way. So can there be any excuse when they do this?
There's none, but let me tell you, what is sycophancy is a much studied subject. It's a pejorative origin came in Greek, ancient Greek. They're called slanderers, not flatterers, like the later time when the Nazis came and Goring and Ribbentrop were accused of sycophancy. You also recall that Mr. Devakant Barua said India is Indira, Indira is India, etc. That's a sycophancy part. But I will come to the role of the judiciary. Judiciary is supposed to be the custodian of the Constitution. It is supposed to protect the citizens from the arbitrary actions of the executive and the legislature. So that's the role assigned to the judiciary by our founding fathers. Now, there has to be natural tension between the judiciary and the the executive, because judiciary cannot be seen as friendly with the high functionaries of the government, showering praises on them. So what justice could be expected from the judges who are so prone to shower praises on the leaders of a particular, or the political leaders? So this is something unacceptable. Barring the example of Chief Justice Bhagwati, you will recall his letter before he became Chief Justice, of course, to Justice Indira Gandhi, where he showered praises. By and large, judges don't speak about the politicians.
Justice Shah,
This is
let me ask you one more question before I take a break. Why did you think it was so important to critically analyze the performance of the Chief Justices during the last 8 years when Mr. Modi has been Prime Minister? Why did you think it was so important to point out the sycophancy of Justices Mishra and Justice Shah? In other words, why did you write that Hindu essay?
The first reason is, I can say that this is my own experience as a Chief Justice. I was Chief Justice of Madras High Court. I was Chief Justice of Delhi High Court, and I know the challenges and the which are faced by a Chief Justice. Secondly, I was really impressed by a book by George Catboys, who wrote a book, Judges of the Supreme Court of India, and in which he actually wrote also about the Chief Justices under whose leadership the Supreme Court was evolved. It's not a critical book, it's more of a reference book. It gives a reference. So that tremendously impressed me. Now I come to the last query of yours, that why should I take that particular approach to last 8 years? Because last 8 years, I thought that there's a judiciary is kind of a completely demoralized and under siege. This is what I thought in last, at least in the tenure of the 3 or 4 Chief Justices. So there is some change now, but therefore that really made me write this article. And of course, this.
And what you were doing is opening the eyes of the Indian people to a truth about Chief Justices and judges of the Supreme Court that the Indian people may not have been aware of. You've opened their eyes to a situation otherwise they would not have known about.
Just one sentence here. Chief Justice of India occupies a unique position in this country, is unparalleled to any other position. He performs the most important functions regarding the appointment of the judges, and secondly, allocation of work. He's the leader. He's the leader of a unified judiciary in the country. So his role becomes critical when we come to the protection of the rights of citizens. So therefore, this was the main reason which compelled me to write this piece.
Justice Shah, we're going to take a quick break at that point. When I come back, I want to raise with you other critical issues that are topical and in the news to do with Chief Justices, to do with the Supreme Court, and to do with how justices are chosen and how they exercise as Chief Justice their powers as master of the roster. We'll be back in a moment's time. Welcome back to a special interview with the former Chief Justice of the Delhi and Madras High Courts and former Chairman of the Law Commission, Justice Ajit Prakash Shah. In part 1, we spoke to Justice Shah about his analysis of all the Chief Justices that have served in the Supreme Court from 2014 till now. In other words, the Chief Justices who held office whilst Mr. Modi has been Prime Minister. We turn now to other important issues to do with Chief Justices, with their powers, with their length of service, and with the functioning of the Supreme Court. Justice Shah, let me first start with the basis on which Chief Justices are appointed. They're appointed on the basis of seniority. My question is seniority the right way of appointing a Chief Justice? Shouldn't more emphasis be placed on their ability and their performance rather than on their seniority?
So I cannot dispute that the ability and performance are very material. And he has to be a Chief Justice, but it has to be his caliber. He should be a competent administrator. He should be a shrewd judge of the men and women. All this is necessary. But I will tell you how it played out. See, after the first Chief Justice died in harness, Chief Justice Kania, the Patanjali Shastri was the next in line. Constitution is silent on the mode of appointment of the Chief Justice. So Nehru wanted to appoint. Chagla's name was in circulation and also Justice Mukherjee's name. Then all the justices threatened that they communicated to Prime Minister Nehru that they would all resign if the seniority is not accepted as a principle. And this is how the seniority was accepted as a principle. As a result, we have judges, chief justices of very short tenures. In 75 years, we are now 50 chief justices. On one end of spectrum is Chief CJI Chandrachud with 7.5 years. On the other end is K.N. Singh. He was Chief Justice only for 17 days. And the one becomes a Chief Justice only by seniority. So we cannot, though some of them are brilliant, like the Venkat Chalaya or Verma, etc. But we should not change this system. If you try to adopt any other method of choosing the Chief Justice, appointing Chief Justice, the executive will pick up someone with a friendly judge as the Chief Justice, and this would completely destroy whatever independence the Supreme Court has retained so far.
I take your point that if you continue to appoint on the basis of seniority, it guards against the executive choosing a favorite and giving him the job. However, the downside of appointing on the basis of seniority, as you pointed out yourself, is some chief justices only have a 17-day tenure. K.N. Singh, who you cited, the present incumbent only has 74 days. Shouldn't the chief justice, even if he's chosen on the basis of seniority to guard against executive favoritism, still get a fixed tenure so that he has time to make an impact?
Of course, that option is open, but this could be done only by an constitutional amendment that prescribing that even if the CJI is appointed on the basis of seniority, he should continue for a particular period. It can be a 2 years, 3 years period. Outside it is 7 years, 8 years. If you see judges, chief justices like Marshall or Holmes, they had tenure of 10 years, 15 years. They had a full impact on the way judiciary function in their countries.
Are you in favor of a fixed tenure, even though the chief justice is chosen on seniority, but he should have a fixed tenure?
Fixed tenure, but the basis should be the seniority.
Okay.
As how it's worked out. It's an academic discussion, so
let's then come to the powers of the Chief Justice as master of the role. These powers allow him to decide which cases are heard and which are not. And this came up, as you know, when we were talking about Justice Ranjan Gogoi and the 4 successive ones after him, critical cases weren't heard. Secondly, as master of the roles, the Chief Justice can decide the size of the bench, as well as the composition of the bench. And this has led Sriram Panchu, writing in the Indian Express recently, to say that the Chief Justice, as the sole selector, can determine the match. And what Mr. Panchu says is that depending on the judges he chooses, the outcome can be more or less determined from the starting point. And given that this fear exists and has been expressed by someone like Sriram Panchu, do you think that the powers the Chief Justice has as master of the roster should be diluted or amended?
See, we have adopted this convention of master of the roster chief. This is the most important function of the CJI, to allocate the work to the benches. Now, this is also followed in Australia, UK, in Canada, and many other countries. But this is a matter of trust and faith. It is normally done with consensus with the other senior judges. This is how the benches are fixed or the work is allocated. Everything was broken during Chief Justice Deepak Mishra's time. The allegation of these 4 judges was that the Chief Justice referred some important matters. When you say importance for the nation, important for the executive, to preferred benches. This is what they said. And they said, as I said, that the Roya's case was a catalyst. So this was the allegation, and everything was broken there. So we can have a more transparent system, which Lalit tried to do through the reforms in the registry. But the trust and faith of the CJI should get from the other judges is very important. It should not be a arbitrary power vested in sole individual. It just see, my view is so dangerous that you need not even is court packing of committed judges, etc. That kind of thing which Indira Gandhi tried to do is not necessary. If you have a friendly Chief Justice and you have some satellite judges in the Supreme Court, the Chief Justice will refer all those matters which are critical to the executive only to those satellite judges. This is even court packing would not be necessary. So therefore, I'm saying that how important this is, that the allocation of work. Secondly, the Chief Justice must keep in mind what Lord Denning said, that some judges are more executive minded than executive. So he must know his judges and he must know the matter and select appropriately where it could be said to be fairly decided by the concerned benches.
If I understand your answer correctly, you're saying that Chief Justices should consult their brother judges widely and transparently to decide which cases are heard and not heard, to decide the composition of the bench and the size of the bench. In other words, it should not be an arbitrary decision of an individual. It should be done in consultation with other senior judges.
That's right. This is what I felt, that there should be some kind of a consultation which would safeguard the institution from the arbitrary allocation of the work.
Now, on the 9th of November, Chief Justice Chandrachud will take over, and he will serve as Chief Justice of India for 2 years and a day. What impact do you think he will have on the morale and the performance of the Supreme Court?
Let me first begin with Justice U. Lalit, and I really feel sorry for him. A very able and very competent judge. Unfortunately, he's getting only less than 3 months. So, and even in 3 months, he had really brought about some change. About Justice Chandrachud, I can say you may take my view as biased because I sat with him, I've seen him very closely. He's a judge with outstanding abilities. You look at his judgments, extraordinary judgments he delivered right from the Puttaswamy till the recent case about the abortions, etc., about women's rights. I mean, the Justice Chandrachud becoming a Chief Justice is kind of I would say that uplifting the morale of the institution by this. It would be a very, and he has got 2 years tenure. So perhaps I believe that he would be able to restore the past glory of the institution. That's my wish, my prayer.
Now, with a new Chief Justice, is this also an opportunity to reconsider how judges are chosen? Over the next 2 years, under Chief Justice Chandrachud, as he will be from the 9th of November, 14 judges will retire and need to be replaced. I know that the present collegium system is a bulwark against the interference of the executive, which you believe must be at all costs precluded. But the problem is the collegium system doesn't always choose the best. Clear proof of that is neither you yourself nor Justice Akhil Qureshi made it to the Supreme Court, and many people genuinely believe you should have. So is there need to change the way judges are chosen?
My personal view is that the judges appointing judges is not a good idea. It was not so envisaged by the Constitution. The ordinarily a National Judicial Commission, appointment commission, would be most preferred way of making the appointments. Having said that, I believe that the collegium system is now in vogue for a long time. The Chief Justice must recognize the faults in the system, the present collegium system. I'm not saying for the complete replacement, you need a new law or the constitutional amendment again. But in the current system, what is the flaw? One is the opacity, the lack of transparency, and secondly, lack of accountability. So the way the judges are selected, there is a criticism very recently I read, and actually I studied I read some surveys. See, there is no logic why a particular judge is picked up from a particular high court. He's at serial number 35, 40. I'm not saying that seniority should be given precedence. I mean, that's not my case. But there is no justification why he's taken, why he's not taken. Now, to demonstrate my point, I'll take Justice Qureshi's line. The court has proclaimed that now the executive will not interfere. It has power to select its judges. Look what happened to Justice Qureshi. While in Gujarat High Court, he decided a case, very critical case against a very high and powerful functionary in the government. So
let's make it clear. You're talking about Amit Shah. It's only fair the audience should know.
Oh yes, of course. And then when he was about to be appointed as acting Chief Justice of Gujarat High Court, he was transferred to Bombay High Court. This is my whatever I heard about him is considered to be a very fine judge, very fine human being. He was extremely popular in Mumbai and wherever he went. And then he was recommended Chief Justice of Madhya Pradesh High Court. Then government objected, no, he cannot be sent to a bigger High Court. So they sent him to Tripura. Then finally he was never taken up. Justice Nariman, it is reported that he insisted that unless Justice Qureshi's name is clear, because he is the senior most and most deserving candidate, he would not agree to any other appointment. And this is how, in Bobde's time, the appointment process stuck. Justice Ranjan Gogoi, in his book, his autobiographical book, said that the government has a negative view of Justice Qureshi. So Justice Qureshi gave a fitting reply at the time of his very, very, very nice reply at the time in his farewells reply to the farewell function. He said he take this as a badge of honor. This government's comment that they view him negatively as a badge of honor. So this is how the executive's interference is now hidden. That's the only difference.
Can I interrupt and point out something that was inherent in your answer? Justice Ranjan Gogoi's explanation for not bringing Justice Qureshi to the Supreme Court is that the government has a negative view of him. And the Chief Justice accepted that as a good reason for keeping a deserving judge out of the Supreme Court. That is another reason why Justice Gogoi, as Chief Justice, didn't live up to the onerous responsibilities and duties of the job. We didn't mention it in part one. I'm glad you brought it up here. That's one more, if I can use a colloquialism, nail in Justice Gogoi's legal reputational coffin. Let me come to my last question. It is to do with a very recent issue, which has once again brought the Supreme Court into fresh controversy. Was the Supreme Court right to stay the Bombay High Court's decision discharging Professor Sai Baba? Or was the Supreme Court wrong both to hear the matter in haste and thereafter pronounce its opinion in haste?
Now, let me just tell you what the case, this Professor Sai Baba and 5 others were charged with under UAPA. Now, there is an important safeguard which is in Section 45 of the Act, which says that the sanction is necessary. Scrutiny of the material against the accused is also necessary. This is to be done by the sanctioning authority. The division bench of the Bombay High Court found that this was not done. In Mr. Sai Baba's case, there was no sanction at all. And the division bench has followed 3 judgments of the Supreme Court. This is under the previous laws, which were on the same lines, like the Tada and Pota, etc. And there are 3 judgments: one Gadvi judgment, then one Brijnath judgment, and some Zaberuddin judgment. All 3 judgments, the High Court simply followed and they said that without this safeguard is violated, and therefore the accused is discharged. So I find it, and this matter was mentioned on Friday, it appears, and it could have come on Monday. I mean, I don't see any reason why such. It appears that the registry was moved on Saturday, and the matter was immediately taken. This doesn't occur well for the. I mean, but what was a great hurry in appeals are filed in course against acquittal, against the discharge, But the state goes to the Supreme Court. I find this should have been done in a better way. And one more thing, I do not find in the order anything on the court's finding about the lack of sanction. In the Supreme Court order, I do not find this issue is dealt with, because I could see that there are several judgments on this issue.
So both the speed with which the matter was heard and also the haste with which the Supreme Court delivered its opinion, both were mistaken. The Supreme Court did not need to rush and hear the case on Saturday, and it did not need to immediately overturn the discharging of Sai Baba by the Bombay High Court. It should have taken more time, thought more carefully, and been more reasoned in its outcome.
This justice should be done, they say, but just appears to have been done, appears to be done. I mean, that's a very important facet of the judicial. So it could have been done if at all the first to be stayed, then this was unnecessary.
So you're saying that in this instance, justice does not appear to have been done. Hasty justice is not justice.
Hasty justice is not justice. You are right.
Justice Shah, thank you very much for this interview. I have to point out that although you were reluctant to pass an opinion on Justice Gogoi, and that is understandable, he is, after all, a fellow judge, but the case that you have built up against him, against other judges on the Supreme Court during the Modi 8 years, and against Justice M.R. Shah and Justice, the other gentleman with him who showered praise, those cases are eye-opening for the audience, because they will make us realize for the first time, and I'm using a colloquialism, how deep the rot runs and how inimical that is to good justice and to good functioning of democracy. Thank you for opening the eyes of the country.
Thank you, Karan. Thank you. It's nice talking to you.
Hi, I'm Karan Thapar. Over the last few years, I hope you've been watching my program, The Interview on the Wire. During that period, I've interviewed doctors, politicians, businessmen, scientists, authors, and even the occasional Nobel laureate. For me, it's been exciting. I hope it's been enjoyable for you. But these, as you know, are tough times, and if this program is going to remain bold, independent, and sometimes even defiant, then I think we need your support. At the end of the day, it's a truism, but editorial independence is best defended by the viewers. So if you would like this program to remain the way it is, forthright, outspoken, and interesting, then would you consider supporting us? All you have to do is to click on the description at the bottom. But more than anything else, I hope you will continue to watch The Interview. Your viewership means an awful lot to me.